today we have him here to speak about a topic which is very practical. IR is not just about trying to handle the union or people or employee issues after they've come up. It is about trying to ensure that they do not come up. And how do we ensure that it's preventive, it's proactive, plus how do we merge them with new labor codes which are around the corner, and everyone's really trying to figure out how things shape up. And certainly, I personally couldn't really think of anyone other than Kabra sir with his over 4 decades of experience into practical realities of dealing with things. And I'm pretty glad that he agreed to share his insight. And I invite everyone here. I'm glad you all could also make time on a weekday to be a part of this. And it's a good thing. Thank you everyone for being here. Kabra sir, over to you.
Thank you very much, Deep, and welcome, my dear participants. This is J B Kabra with around 40 years experience, of which about 20 years were in hardcore industrial relations. And let me brief you a little bit about what industrial relations mean and how they are different than human relations. Prior to that, we need to go to the little bit of history. If you look at it, India never had any industry before about 80 years or so. 80 or more than close to about 100 years. We had only agriculture. Agriculture had its own advantages, its own disadvantages. In agriculture, we had the barter system which was prevailing. Every village was a self-sufficient. And you would trade. You have a goldsmith, you would give him some of your grains which grow, and in turn he would attend your work. Then came this, the little bit of industrialization started. The first cotton textile mill started in Nagpur, somewhere in around 1875 or so. And then the industrialization started, which was the main hub was Mumbai, and with the cotton textile. Once upon a time, we had almost close to 100 top cotton textiles in Mumbai. And these cotton textiles, they made a brisk of business, and they were competing with the Britishers. And when the Britishers saw that India has a lot of advantages, because of the Bombay has a humid weather, which is good for cotton textile. It has a lot, very rich cotton growing belt, which is around, cheap labor, and so many other things. And therefore, Britishers saw that the cloth which was imported from British became costly as the Indian cloth became cheaper. To make this cloth dearer and costlier, what Britishers requested the then East India Company to bring the labor laws and industrial relations whereby Indian companies would lose their competitive status. And that's how the industrial relations started. The first act promulgated was Factories Act in 1885. And that first Factories Act said that no worker shall be required to work before sunrise and after sunset. That was the working hours. And from that, we have progressed to 48 hours a week or 8 hours a day. See, imagine the kind of thing. And then what happened was, when the industries came, a lot of labor came, a lot of migratory labor, they came in. And in Mumbai, it was full of workers who were mainly employed in textile mill. And their rights were to be protected. And for the first time, the first labor leader was again a Maharashtrian gentleman called Narayan Meghaji Lokhande, on whose name my institute, where I post-graduated from, is named Narayan Meghaji Lokhande Maharashtra Institute of Labor Studies. And believe, the first strike was organized by none other than Mahatma Gandhi, the person who fought for Indian freedom movement. The Indian freedom movement and the labor movement were almost going hand in hand. There were many labor leaders who had given up their life to the cause of the labor. Example of Rashtriya Mil Mazdoor Sangh, Mr. late G.D. Ambekar. He never got married because he wanted to serve the labor. And the Pratap Mill Amalner, where Babu Genu, because the Britishers were sending their cloth and it was going in the truck, he laid his life. He laid before the truck and the truck crushed him and he was killed. So you would find that the labor movement had some kind of a national spirit. This continued for a while. We had leaders like Comrade S.A. Dange, Sripad Amrit Dange. And most popularly, because they have a red flag, they were called as a Lal Bauta. Lal Bauta. They became very, very famous, very, very famous. And thereafter, every political party, name the political party, and they had a labor wing. Say if you take it Communist Party, you had a labor wing. Communist Party of India, you had ITUC, All India Trade Union Congress, and their leftist wing had a C2, Center of Indian Trade Union. The National Congress, which was Congress at that time, Nationalist Congress, it became, its labor wing was called as a INTUC, Indian National Trade Union Congress. There was another wing of the communist people, and they had a labor union called UTUC, UTUC, that is United Trade Union Congress. Then came the Hind Mazdoor Sabha and Hind Mazdoor Panchayat. They were the ones which were led by none other than the socialist people. So even today you will see that today it is considered as one of the finest method to enter into national politics is either you become a student leader or you become a union leader. Then this continued for a while. And each political, they had ideology, workers had ideology. There was something which was called Bombay Industrial Relations Act, which the late Dr. Datta Samant used to call it as a Black Act, because it had a recognized union, one union in one industry principle, August principle was upheld. But he never wanted that. And therefore, BIR Act was described by him as and that is where what happened was, thereafter the violence in the labor fields erupted. The Crompton Greaves, there was a violence. Godrej, there was a violence. And there was one situation which became so powerful, and people would say that if Datta Samant's union is there, you will get 3 letters in one envelope. One will be notice of formation of union, second will be charter of demand, and third will be notice of strike. You have to accept one after another. Similarly, at that particular time, Pune, which was another belt, industrial belt, and it was an automobile hub. Very big companies like Telco, they had one funny method of agitation, and that was the almost 10,000 employees of Telco undertook fast unto death. And they were gathering near that, ground near Shanwarwada. Rajan Nair was the person who was leading that particular. Imagine if a couple of them would have died, what would have been the fate? Ratan Tata was ready to have a negotiation. The then Chief Minister organized a meeting. Ratan Tata was there in time, but Rajan Nair, for best reasons known to him, he did not. And therefore, government decided to break the strike. The ST buses were called from all over. The people were dumped. They were taken outside Pune, and they were left halfway through. And that's how that particular strike was crushed. Now you will find that in industrial relations, so industrial relations are collective part. We represent as an employer and they represent as an employee. They come together, and therefore in industrial relations, the most important thing is it is like two wheels. Both the wheels have to be equally strong. Employer have to be strong, employees have to be strong. And that particular time, if employees were unionized, employers also were unionized. We had in Mumbai Mill Owners Association. So they were fighting with RMMS, Rashtriya Mill Mazdoor Sangh. They would decide for everybody and the matter would be decided. But Datta Samant never agreed to this kind of thing. They were representative union. He should have waited for them to lose their representative status and put up his application for getting the representative status. But he did not. It started with a bonus of a couple of 8 mills, which were doing reasonably well. Others were not doing well. Where it was 8.33, other units, it was declared a little bit more. He said, no, we want 20% in all the things. And that is how the strike started. World's biggest strike is noted as textile strike of Mumbai. On paper, it continues even today. But the fact still remains that none of the textile mills are left in Mumbai. All of them have down their shutters. And from there onwards, the fall of the trade union movement came. Look at the funny part of the industrial relations in this country. In this country, industrial relations are not a bipartite process. That is, the matter is not left between employer and employee to decide. It is a tripartite process. Government jumps in And the dilemma for the government is the biggest employer. So they have a double role. One side they have a role as an employer, other side they have a role as a mediator between employer and employee. And it is called as a tripartite process. Another unfortunate thing which happened during those days, the industrial relations were based on basic atmosphere of distrust. Every employer would expect his employees to do a lot of work, not to ask for any holiday, no leave, work, and for doing that work, whether I should be paying you wages. And look at it from the employee's point of view, they were wanting every facility, more leave, more paid holidays, more wages, more bonus, more other benefits. And to get all this, am I supposed to work also? So if you look at it, the relations were contradictory to each other. And a period up to 1980, 1982, 85, 90, close to 98 was the worst period as far as industrial relations were concerned. At a throw of hat, there would be a strike. I know there were strikes on size of that batata vada. Batata vada is one of the snacks which is most popular in the city of Mumbai. There was a strike. There was a case where there was a strike because company changed the butter for that, you have that sandwiches. So company once upon a time was giving Amul butter. They changed to other brand because Amul was in short supply and the people went on strike. So you were having strike at the throw of thing. And this became this thing. And for the first time, when the collective bargaining, what we call in industrial relations is called collective bargaining, it became coercive bargaining. Coercive bargaining. Arm twisting techniques. People resorted to various unfair labor practices, so much so that the company where I was working, we were manufacturing the glass bottles, and the people, because we had industrial relations issues pending at that particular time, the people started doing exactly reverse, throwing away the good bottles and packing away the bad bottles. So double way the company is at loss. What to do? Company like a Bata, they were the biggest manufacturer of footwear. But when the company had little IR issues, workers started manufacturing only one leg, one leg shoe. If they were manufacturing only right leg, no left leg inside, no left shoe. Or one shoe would be 6 number, the another one would be 7 number. So naturally it will come back, companies into deep trouble. That kind of industrial relations we had. Strikes were rampant, lockouts were rampant. Go slow, most dangerous form was rampant. It was very difficult to prove because people would call it as we are working as per rule. And therefore it became a problem. It was a highly reactive IR. Reactive IR. And even the employer, I would also like to blame employer because they have to also share some part of blame. When the employees would come with a folded hand, sir, we cannot manage in this kind of a wages, please increase. They would say, no, I have no money. I don't have capacity. But if the same people join the union, come with a danda and jhanda attached to it with a flag, the same employer who was not ready to share 50 rupees, how was he sharing 500 rupees extra? So the basic principle of IR was ignored, that you have to be fair and then firm. The employers were neither fair nor firm. And that is why the union became more and more aggressive. They were not saying, they were saying we don't want. I know Dr. Datta Samantli, I have highest respect for him. But he used to say one thing. He used to say, as far as the balance sheet is concerned, I used it as a tissue paper. Throw it. This is what I want, you have to give it. And then it became a problem. It became a problem. All textile units became sick. The employers, they got this as an opportunity. They sold their land for crores of rupees, and the entire textile units from Bombay were wiped off. So much of trouble. Initially, we had a lot of manufacturing activities at Kolkata. But Kolkata again had its own share on industrial relations. What was happening in Kolkata? That time the communists were there. So there, every day there would be a strike, morchas, gherao, manhandling, this, that. So the companies shifted their base to Mumbai. Again, Mumbai became the same. Companies shifted to Bangalore. Bangalore also it became same. They shifted to Uttarakhand, Rajasthan, Madhya Pradesh, Chhattisgarh, and so on and so forth. So the point, ladies and gentlemen, I'm trying to tell is you have to respect each other's thing. And so the industrial, one thing which is very clear, I'm a HR, basically HR person. But remember one thing, people will work, therefore it is policy is called as a carrot and stick. So carrot is probably, and we used to say in the industrial relations, because the moment he completes 240 days, he is deemed permanent, whether you see him later or otherwise. And now you cannot do away with him. I used to say jokingly, if you want to give a divorce to your spouse, it is possible. Or your spouse wants to give a divorce to you, it is possible. But you could not give divorce to your employee. And that became a problem. And because of that, the people became that the complacency came in, arrogance came in. The work, the productivity was a biggest hit. There were no agreements which were linked with productivity. The union would demand, and the skill of a HR manager or the IR manager was, if suppose they have demanded, say about 5,000 rupees, what is my skill in reducing that amount? But nobody ever tried. Can we not link it with the productivity? And for the first time, the concept came, which is called as a management charter of demand. And how did it came? There was a company called Caltex and Esso. Both were multinationals, Caltex and Esso. And they later on merged and became Hindustan Petroleum, later on, after independence, I believe. So Caltex and Esso, the union submitted charter of demand, and the management also told them that, look, we also have certain expectations from you because we want to get something in return. And they submitted. And you know what? What was the reaction of the union? The reaction of the union was, you have insulted us. How can you as a management submit a charter of demand on us? So now our demand is management should withdraw its charter of demand. That became demand number one. The natural negotiations failed. Bipartite negotiations failed. Matter went to conciliation. We have a conciliation. In a conciliation, the matter was admitted, but the conciliation officer, a typical government labor officer or assistant commissioner of labor, I don't know as the case that time, relevant time, he got confused. He said, all these years, I have seen only union charter of demand. I have never seen management charter of demand. And how can you raise a management charter of demand? So he said, I am admitting only union's demand in conciliation, and I'm not admitting management's demand in conciliation proceedings. The matter, failure report, matter went to the court, and there the union, the management said this reference is bad in law because our demands have not been considered. And then the court ordered that the fresh conciliation proceeding should start, where both of them need to be admitted. And that's how for the first time the management charter of demand came. Another trouble, as I was talking to you, biggest employer is a government. Another trouble with the government is we have a public elected government. And because the public elected government, in the democracy, it is bound to be there, the government or the politicians would be interested in votes of employees and notes from the employer. That being the case, major reforms was impossible. Impossible. Because you cannot displease both. Therefore, keep it pending. Keep it pending. If you, because please remember, you cannot, as though under our constitution, Indian constitution permits something called as a fundamental right. So fundamental right to do a business is a fundamental right. But please remember, ladies and gentlemen, its chronology, not to do a business is not a fundamental right. This was upheld in Lakshmi Engineering Works Coimbatore versus Government of India, where Section 25O of Industrial Dispute Act requires to obtain permission if you want to close down or retrench or lay off the people. Now that limit is increased, that I will see when we talk about the various codes we are talking about. And they said, if we accept not to do business as a fundamental right, what happens to the fundamental right of employees who have a right to earn livelihood. And therefore, your right, which if it comes into the way of a right of employees, is not a fundamental right. And therefore, the limitations imposed by Section 25O cannot be called as something unusual. And therefore, it is not ultra virus of the Constitution. The discussion was held. The matter got closed. So please remember, therefore you require permission. For layoff, you require permission. For retrenchment, you require permission. For closure, you require permission. Strike, you had in public utility services, the strikes were slightly prevented because giving notice, 14 days notice was obligatory, and the moment notice is received, it would deem to have been admitted in conciliation. So in public utility, still it was happening. The government departments, whether it is railways, whether it is airport, whether it is Air India, airlines, whether it is your banks, public sector banks, the people were going on strike. Municipal corporations, people were going on strike. All of you are aware Prince Charles came, and that time our people went on strike because they wanted Mr. Prince Charles to see how dirty our city is. So these are nothing but the arm twisting technique. I know there was a public sector undertaking which was a road transport undertaking, and the driver would drive so slow that even a bullock cart would overtake him. And if you question him, no, I'm working as per rule, so I won't do the overtake and all that. The distance which should have been covered in 40 minutes, he was taking 2.5 hours. How to do? And therefore, it became a problem. It became a major issue, and this became a matter of high. The court judgments came in. Another important thing is we have a law, and we have followed the British laws. British laws, plethora of laws, all old, outdated laws. But we never, and in Maharashtra, our state, because it is a progressive, we are progressive even in labor legislation. We had another law, which was called as MRTU and PULP, Maharashtra Recognition of Trade Union and Prevention of Unfair Labor Practices. The basic purpose was that there should be a recognized union, but the people forgot that recognition part. They were going only into unfair labor practices. And this is the only act where there is a provision of injunction. And if I want to take any action, propose to take any action, the other party would go to the court, get an ex parte injunction, and now it is for me to fight to get that injunction vacated. As of today, there are almost 2 lakh labor matters pending only in Maharashtra. So that happened. And then came the third phase came, that is liberalization, privatization, and globalization. And when we wanted the foreign direct investment to come in, those people said, we are ready to come invest money in infrastructure and other projects, but your labor laws are prohibitive. And thereafter the government started thinking how it can, that is called ease of doing business. To do that ease of doing business, government had to come in. And therefore, if you see that thereafter, naturally, the industry itself went down. There were hardly any companies left. Otherwise, in Bombay, we had a LBS road, which was full of factories. We had Thane-Belapur belt, which was full of factories, Asia's biggest industrial belt. We had Waghla estate, another big estate. Most of the units got closed and they were transferred. They shifted their operations to other states like Gujarat, Rajasthan, and as I told you. And therefore, then the government started thinking that unless and until you have an ease of doing business, please remember hire and fire policy, which is prevailing in the other countries like USA, probably will not have any place in this country. And according to me, if you ask my honest opinion, should not have. Because our problems are different. We have a lot of population. We have a lot of people who want an employment. And if we give a blanket permission, then something like pink slip, probably it will not work. But now in this, what they have given is, in this code, what they have introduced is something which is called as a fixed term employment, FTE, where you can have an employment for 1 year, 2 year, 3 year, predetermined period. And at the end of that particular period, his employment would come to an automatic end, and which would not be treated as a retrenchment under the new code. And therefore, you would be able to conclude that particular contract. Only thing is, Provident fund you have to give from day one, you have to give ESI, you have to give bonus, you have to also give gratuity. Because under gratuity, employee is entitled to gratuity only if he completes 5 years of continuous service. But since it is a fixed term employment, even if it is 1 year, you have to pay gratuity for 1 year. So that's how the things started. As I was telling you, that the most of the employers were also going into the reactive hire. Some of the employers, they say, attending, punching the card and thereafter going to the work. It was not happening. People were punching the card and spending time in canteen, spending time canteen in restrooms. I had myself caught one of the employees. He should have been at a workstation at 8:30, 9:15 when I took a round and I entered into the washroom. He was reading newspaper. And you know the answer he gave? Reading newspaper is not a crime. I said, certainly not. But reading newspaper during working hours is a crime. That kind of a thing, that kind of a indiscipline had touched to the height, because people knew that nothing is possible. And please remember, between employer and employee is supposed to be weak. And our constitution makes it mandatory to protect the weaker section. Now, between employer and employee is supposed to be weak, therefore he is to be protected. Between husband and wife is supposed to be weak, though fact might be reverse. I'm not getting into that. But therefore, her voice has to be heard. Between tenant and landlord, tenant is supposed to be weak. And that being the case, in over enthusiasm of protecting weaker section, probably dismissal became almost impossible. Because of that 11A, the punishment has, under Industrial Dispute Act, the punishment cannot be grossly disproportionate to the seriousness of misconduct. In that, the people would work. The court would always ask question, if you give one more chance, do you think the heavens would fall? And the trouble with the heaven is they never fall. And that is how, with the industrial relations, it reached to the peak. The personal managers were being hit. The employers were being hit. There were murders, quite a few murders. Inter-union rivalry was at rampant. And when this particular thing came, then the codes came in. As I was talking to you, there is a plethora of cases. Our Indian Trade Union Act was 1926. And the funniest part is any 7 people coming together can form a union. And the moment union is formed, employer would feel that he's crippled, his hands have been chopped off. I'm not against social security. It has to be there. But at the same time, there has to be a balance. And probably for the first time, though the talks had begun, even before this government came in, it started right from Manmohan Singh's time. But by the time you make a public opinion, you get into this, pass these codes, etc. 2019 came up and 4 codes were passed. And these codes were, the first code was wages code. Now, what did wages code comprise of? It comprised of 4 acts. The first one was the Payment of Wages Act, Minimum Wages Act, Equal Remuneration Act, and Payment of Bonus Act. They were merged together and it became a wage-related code, which was passed in 2019. Ladies and gentlemen, please remember, these codes are yet to be implemented. None of the codes have been implemented. Yeah. Yes. None of the code has been implemented because under the code, central government and state government have to form the rules. They have to invite objection from the public. And once these subsets of the rules are made, then probably in one of the webinar, the secretary, labor secretary had said, central labor secretary, that he is hopeful that these laws would probably be implemented. These codes would be implemented from 1st April of 2021. So the first code was the wages code, which was passed in 2019, and balance 3 codes were passed in 2020. At the same time, our agricultural 3 reforms came in. But as you are aware, there is a lot of turbulence going on the agriculture. Therefore, this has taken backstage. But probably, I don't know, there has not been much of a hue and cry on the labor codes as it has been for agricultural reforms bills. But we don't know. We have to keep our fingers crossed what will happen. So the second code was the second code which came into existence. You know, again the question which was asked before this act came is as I was talking to you, the government is the biggest employer. The question came whether government has any business to be in business. Can you believe our government of India was running hotel through Hotel Corporation of India? Now, to run a hotel, is it a business of a government? So these were the fundamental questions which were being asked. Should we not leave it to the private players, electricity generation, electricity distribution, transmission? They were all controlled by the government. And because of the inefficiency and low productivity, none of these companies were making any money, except those Navratnas, because they were in a monopoly sector, like petroleum, oil and natural gas, because there was no competition. The moment the competition came in, you can see what happened to MTNL, what happened to BSNL, what happened to various electricity boards. None of the electricity boards, even though they have made a company, Maharashtra Electricity Distribution Company is in a loss of 70,000 crore. Because we have a populist method. We want to give free, everything free. 100, the Delhi Chief Minister, he said electricity will be free up to a particular unit. The moment you start distributing freebies, where the money will come from? And such kind of a public sector undertaking will bleed. So the second code which came was called as a occupational safety and health, and working conditions. And there the Factories Act, there the Contract Labor Act, there the Plantation Act, there the Mines Act, the coal mines, mica mines, as so many acts are there. So those acts were all merged, 18 acts, more than 18 acts, and it became a occupational safety and health is of a matter of prime concern. Major thing came after that Bhopal gas tragedy. Major thing came that you have to have a structural stability, because we had one company in Taloja near Thane where stability certificate, they were putting the revolving machinery, moving machinery on the first floor. The building collapsed like a pack of a card. And then the government said, you have to have a stability certificate. So all such things were merged. Then came social security, because every employer is put to a lot of insecurity, put to a lot of insecurity. He has to retire, he has to have a money to fall upon. He has served loyally to his employer. Therefore, employer should, out of gratitude, he should pay him something. Therefore, it is called gratuity. Gratuity. He must also get a share in the bonus, profit sharing. Therefore, bonus. There is always a debate whether it is a social security legislation or it is wage related. According to me, it is a wage related legislation. The reason being very simple: you have to pay 8.33 minimum, which means nothing but 13 months wages for 12 months work. Therefore, it's only deferred payment. So whether then ESI, the workman is likely to meet with an accident. He is likely to meet. He may be, there is a temporary disablement, permanent disablement, partial disablement, total disablement. Anything may come up. Under Provident Fund, everybody has a dream of having his or her own house. Where the money will come from? You have to look after the kids' education. Where the money will come from? So to provide that, Justice Gajendra Gadkar Committee was appointed, and under that, the Provident Fund Act, ESI Act, Provident Fund Act came in 1952. Today, we are the world's largest Provident Fund organization with close to 6 crore members. ESI Act, Employees State Insurance Act. The female employees are forced unemployment because of maternity. So Maternity Benefit Act. Where the ESI is not applicable, they are automatically covered under Maternity Benefit Act. Payment of Gratuity Act. Out of gratitude, you have to pay. Therefore, the Payment of Gratuity Act, all these got converted into what we call as a social security legislation. And then came the IR Code. IR Code, it combined Industrial Employment Standing Orders, Act 1946. Then Industrial Disputes Act, and finally Indian 1947 and Indian Trade Union Act 1926. They were merged, and then came the Industrial Relations Code. Under each code, now they have tried to, with this, what has happened is even inspectors, their designation is changed. They are no more inspector, because they are called as the inspector cum facilitators. They are expected to facilitate the process. Obtaining licenses, renewal, whether it is factories license, shop and establishment license, etc. It is now everything online. And with single application, all applications will stand renewed. So let us see what are the important thing, which is, when we will be discussing there. Here only I'm talking of the only salient feature. The definition for as far as the Social Security Wages Code is concerned, any worker, any person, irrespective of what category, what title you give him, if he is drawing up to 18,000, he will be covered under this wages code. And again, another thing which they have said is, earlier to raise a dispute, the period was 3 years. Now it has been brought down to 2 years. And major change which has happened, of course, I'm talking now. Actually, I should have talked it about when I'm talking, but since it is a major change, earlier you were required to obtain government permission under Chapter 5B of Industrial Dispute Act for layoff, for retrenchment, for closure, if you were employing 100 and more. Now this limit is gone up from 100 to 300. I mean, it proposed 300. So up to 300, it is only employer-employee relationship. So even if you terminate, even if you mass retrenchment or a closure, or you don't require to take a permission from the government, and no government would give you the permission, as I told you. So now the permission is not required, but of course they have increased the compensation amount, that we will see later. The another important thing is, for grievances, employees have grievances, and unless and until these grievances are addressed, please remember, grievances of today, yesterday, they will become disputes of tomorrow, and that is called proactive IR. And therefore, grievance is, I get a feeling that I am somewhere being victimized, I am being harassed. So that grievance may be real, may be imaginary. Workers' participation in management was a part which was included in industrial relations. Forget of workers' participation, even today, managers don't participate in management. So workers' participation is a big story. But then the point is, it came that from 6 members, it will be taken to the 2. Now, who would be the employer? Because many times people would escape that I'm not an employer. They said employer definition is very, very the same. They say it could be HOD, head of the department, it could be occupier or manager under Factories Act, it could be the contractor, it could be legal representative of deceased employer. Suppose the employer is dead, they say, who is the employer now? Employer no more, but legal representative of employer is also deemed to be an employer. It's a good change, good change. So the people cannot, anybody who has got an ultimate control on the affairs of the company will be deemed as an employer. And the workman is anybody who is doing work, manufacturing process. Even godowns have been included in the definition of factory now. Godowns. So it is premises and precincts, but the limit has gone up under Factories Act. Earlier it was 10 and 20, 10 with power and 20 without power. 10 without power and 20. Oh, sorry, I'm sorry. 20 without power and 10 with power. Now it has been doubled. It is 40 and 20. But wherever there is a hazardous operations are going on, it is the powers are still with the inspectors, factory inspectors, which are now, they are called as the Director of Industrial Safety and Health. They are with them. So if there is a dangerous operations, there are certain operations which are dangerous, where the compressed air is used. Please remember, if there is a fatal accident, the fine amount is 5 lakh, an imprisonment which can go right up to 2 years. But earlier what was happening, most of the accidents take place because of, there are 2 reasons. One is unsafe act and second is unsafe condition. For unsafe condition, employer can be punished. But what about unsafe act on the part of employer? Now they have been also held accountable for their own safety and health. And if it is seen that the accident has happened because of carelessness on the part of employee, he will also be fined. He will also be prosecuted. That's a probably one good thing that has happened. Only from the definition of industry, what they have done is from definition of industry, they have specifically excluded charitable institutions, philanthropic institutions, social institutions, and those companies which are engaged in sovereign function. Like for example, military. You cannot, the military people cannot afford to go on strike. Police cannot afford to go on strike. Therefore they have to be excluded. And as far as the wages is concerned, where there is going to be a major impact, the wages are divided into two parts now. One is called as the basic, the reimbursement allowances, and the anything which can be expressed in monetary terms. And part two, certain things have been excluded from the definition of wages. And what are those things? They are bonus, they are conveyance, they are HRA, there is overtime, there is a commission, sales commission, provident fund, gratuity, retrenchment, compensation, etc. But they have put a cap. And what is the cap? Part two cannot exceed more than 50%, which means if the rule gets through, which means if your gross is say 10,000 rupees, what we call as accrual and non-accrual area. So the accrual area which will attract provident fund, which will attract all other retirement benefit is called accrual area, has to be 50% of the monthly gross. And when it is a minimum wages are concerned, they have also introduced something called floor wages. And your minimum wages cannot be less than floor wages. And the floor wages, they will be revised, the government will have authority to revise these wages once in 5 years. And once they do it, if your minimum wages are more than floor wages, you have to give minimum wages. But if your floor wages are more than minimum wages, you cannot reduce them to minimum wages. So it will. And please remember, Supreme Court had said, if the capacity to pay is immaterial, if you cannot pay bloody minimum wages, you have no right to exist. So you have to pay minimum wages. There is absolutely nothing. Nothing. In the Minimum Payment of Wages Act earlier, it was only the coin or the currency note, and you had to obtain the consent of the employee either for paying by check or paying through bank transfer or through that various these Paytm and all that. Now they propose that it is a matter of availability under the law itself. You can do that, and therefore it is an important thing. And wherever there is a if suppose you have a company which has got more than 300 people, and there if you do not follow the provisions for retrenchment, for closure, for layoff, then the fines and the imprisonment, those are very, very high. The fine could range from 1 lakh to 10 lakh, and the imprisonment, it could be up to 2 years. Yeah. Now, yeah, there is one question which has come from Samir Banerjee. I'll answer those questions little later. That if one company has got a branches, head office somewhere and the branches, they will have, as far as this thing is concerned, they will be also connected with the both central as well as state will be applicable. For public sector undertaking, it is the central labor commissioner, whereas for other, it will be a state labor commissioner. And of course, the matter needs to be yet finally cleared. And another thing they have said, first time, because now with the advent of IT, now what has happened, many people are working from home. Many people are not organized. For example, I'll give you the example of delivery boys. You know that Swiggy and then Zomato and then your, what is that, MACD. Now those people come and deliver. They are delivery boys. They have been also covered. Zig workers and platform workers. Now, those who are working in isolation, independently, they are working platform. They are freelancers, they are project-based people, they are also covered. And there are various platforms on which you work. I mean, the work from home through various IT-enabled applications. Those people have been also covered under this thing. And therefore, to that extent, the law becomes, except for domestic services. except for domestic services where you have a maid, maybe one or two maids, then it is a different thing. And what has happened is, as far as the registration is concerned, you can register with single stroke. Applicability will happen only when you qualify for application. But as far as ESI is concerned, they have said we can consider the they call the optional coverage. And now ESI is applicable, proposed to be applicable on all 740 districts of the country. Of course, those limits will be there. You know, Provident Fund limit will be there, for ESI limit will be there, payment of bonus limit will be there. You know, the eligibility limit for payment of bonus is 21,000, but calculations are made on 7,000. So you 8.33 are to pay. And another major change which is proposed, which is likely to impact, is earlier, I don't know, I'm not too sure, because what they have said is you have to pay of the gross profit, it has to be shared. Earlier, from gross profit, we used to calculate net profit. From net profit, we used to calculate available surplus. From available surplus, we used to calculate allocable surplus. Then there were provisions related to set on and set off. So what happens to them is yet to be seen. You know, so I'm keeping my fingers crossed. So if that happens, then probably it would be a major impact. Major impact. See, as far as minimum wages are concerned, the moment you are paying below, you are paying up to minimum wages, then everything, irrespective of what title you give, except probably HRA is now out of the minimum wages, everything will be covered for PF. So earlier people used to do what? They used to keep a basic as a very little. If the salary is 30,000, basic would be as low as 5,000. So PF was being calculated only on 5,000. So which probably is not. So it is going to have the implication. But to do ease of business, also if you retrench, you have to even, you have to pay gratuity, as I told you, without applying the limit. You have to also pay the retrenchment compensation. And there is something which is called as a skill development fund. To that skill development fund also you have to contribute. So with the fund created, the government proposes to rebuild the skills of the people, because certain skills have become obsolete. So the people need to go through those skills, acquire new skills, and for that this particular fund has been created. So this is what is happening. The suspension pending inquiry. Earlier there was 50%, then it became 75%. For first 90 days, suspension allowance is 50%, and then it is 75% after 90 days without any limit. Earlier it was 100% after 180 days. Of course, in some of the states it has already gone, and they have sealed it at 75%, but some state it was still going on. So the model standing orders, the sexual harassment of the act, everything. IT industry is exempted from filing a model standing order. See, what happens is, as far as the IT is concerned, they are considering some different set of law. Also, those industry which are located in export promotion zones, like say Santa Cruz Electronic Export Promotion Zone, or Kandla Electronic Promotion Zone. So there probably also you must have seen, for the working hours during the pandemic, many workers from UP, Bihar, Jharkhand, they left. And those governments, they said, all right, now you want to work, so we will make sure that you get employment, temporary employment there. And there they were asking they were thinking of permitting employer to extend the working hours from 8 to 12. Of course, most of the cases they were opposed, and it has not seen the light of the day. But the government, what is the amount of skill development? It is the 15-day salary per completed year of service. It has to be again deposited with the skill development fund. Therefore, what has happened is, employer would say, Baba, I have no problem in paying the money, but don't make permission mandatory for me, because to get a permission is a hell. And therefore, I don't mind shedding extra money. But therefore, you will see that industrial relations, people say, sir, where are the unions now? Where are the industrial relations have gone? HR has taken over. But let me tell you, now the situation is not the same as it was. Earlier in IT industry, if you used to tell him okay, that, oh, I need to, subject you to disciplinary action, he would submit the resignation because he would have appointment letter practically in each and every pocket. But today's situation is not so. And you must have read about a year and a half to 2 years back, the first union in IT sector also came up at Hyderabad. So probably what happens is people say, when my tummy is affected, then the people would definitely go to the extent. And therefore, now what needs to be done is it has to be a combo of HR and IR. Ladies and gentlemen, combo of HR and IR. See, HR came up in this country because under IR you cannot sack him. So if you cannot sack him, can we think of changing him? That is the reason why HR came in this country. Don't think the employer had great love for people. No, because it was like a homeopathic medicine. All right, whether the disease is cured or otherwise, at least patient won't die. And that's how the HR came. But I always say HR and IR are the two sides of the same coin. You have to be fair, you have to be firm, you have to be assertive. You must put yourself into their shoes and they must put themselves into your shoes. Now, how do you do that proactively? Proactively. Future of IR post-pandemic, yeah, in the codes. See, what will happen is, as I told you, those people earlier in my institute, we were supposed to be the IR expert, but then IR took a back seat, and then IR was converted into HR. But today, let me tell you, advent of IR will take place with these new codes in place. And therefore, if earlier employees were pushing employer to the wall, now if it happens that employer pushes employee to the wall, again, it will be a reactive IR. No. Like in my emotional intelligence session, I had said that you must put yourself into their shoes and they must put themselves into your shoes. Then only things will work. But one thing is there, the people will not work. Yes, these are all questions which probably there is a registrar of trade union. That act also has been incorporated. They have to submit the annual return. If they are not there, then the credentials will be checked. The union can be de-recognized. Even the provision was earlier also there. You can de-recognize the union. Who will check the union credentials? Question from Samir. Yeah, so it will be the Commissioner of Labor, but their role will be now not only the law implementing agency, but their role will be also educating people. And therefore, the life will become little easy, but you have to shell out more, probably people. So coming back to the point, please remember, it is a carrot and stick. In HR, it is a carrot. You say, oh, sir, you are so nice. Why don't you behave properly? Do this, do that. That is nice for you. The fellow will never work because each time he will ask for a bigger size of a carrot. Sir, last time also you gave so much of only. Now increase, increase, increase. But how do I increase? There are limits. But if he knows that if you don't respond to the carrot, I don't mind using the stick. Therefore, it is called as a carrot and stick policy. I asked one of the employee who had put in a lot of years of service. I said, sir, I know you are employed for the last 20 years, but when did you started actually working? And the answer he gave, ever since company threatened to sack me and fire me, I started working. So please remember, too much of job security is bad. Too much of job insecurity is also bad. If I am under constant pressure that when I go home on Friday evening, by the time I come back on Monday morning, whether my name will be still in the muster of the company or it would have been deleted over the weekend, then also people cannot perform. And if there is a too much of job security, he knows company cannot do anything. Let them do anything, but they cannot sack me. Then naturally what will happen is arrogance will come. The people will. Therefore, what you should see, recognize union is under law. See, under BIR Act, there was a provision for what we used to call as a representative union was recognized. And once the recognition is given, you have to only talk to that union. In Maharashtra, we have MRTU and PAL. Once the union is recognized under MRTU and PAL, that is Maharashtra Recognition of Trade Union and Prevention of Unfair Labor Practices Act. Refusal to negotiate with recognized union is a unfair labor practice, but refusal to negotiate with unrecognized union was not an unfair labor practices. So, but then MRTU and PULP kind of act were there in only 1 or 2 states, and Maharashtra was one amongst them. But the other states, therefore under ID Act, you can have several union. They were, yes, contract workers also can form a union. Absolutely no point. If contractor does not follow some of the suggestions or the fact, it will be the responsibility of the principal employer. Even in ESI, they have made a major change that earlier what used to do, because if for any reason employer has not made a contribution, then you were not entitled for benefits of ESI. They were corresponding contribution period and benefit period. Now, irrespective whether the money has been contributed or otherwise, the benefits will be paid by ESI. Now, you are also aware that ESI, recently, I think this announcement was made only about 15 days or 20 days back, that those employees who lost their job, ESI is paying them 3 months salary. ESI. Again, in the PF also, that during the pandemic, what they had done was employer as well as employees' contribution was paid by government. No. Now what will happen if the place is not notified district? Now what they want to do is all 740 districts will be covered under ESI. Earlier, what you say was absolutely right. It was called locational coverage. Locational coverage, because they were not having facility. Now either they will have their own facility or they will tie up with the other hospitals, and ESI will become automatically applicable. When ESI is applicable, 2 acts are not automatically, they cease to be applicable. One is Maternity Benefit Act and the second is Employee Compensation Act. They will be, yeah. Though can we employ all the employees? Because the rules are yet to be specified. Fixed term employment. They say if there is a temporary rise in the work, or if there is some project which is likely to be over, then you can go for it. But many people, they have said that this particular work has come up temporarily. Of course, the rules are yet to be framed. Therefore, I cannot tell with 100% confidence and concrete answer. But yes, what we do is, for example, a hospital where I am working as their HR advisor, what we have certain projects which are sponsored by sponsoring agency. Like, for example, we have some companies like Lions, Rotary, they sponsor. The project could last for 3 years, 4 years, 5 years, 6 years. But the moment they withdraw the financial support, the project will come to an end. So we call it as a project-based employment. It can be for a fixed period. So you can have for 1 year, extend it depending on, and put that particular clause that it is, since for any reason the sponsoring agency, if they withdraw the support, the matter comes to an end, over. Yeah, we can do no permanency clause will come into this as it is proposed now. I know the IR is such a subject, law is such a subject, you will have n number of questions. And as I told you, right now it is wait and watch, but you have to proactively deal. Like, for example, there would be always. So can we not have, there are some companies which they say that you report, go to the canteen, eat, drink coffee, tea, and by the time you punch your card, it will be in the workshop and the time will be counted from there onwards. So automatically, it's become proactive IR. You know that there is some kind of a murmuring going on. Can we deal their disputes in advance, grievances in advance? Because they will have any problem of today, they will have their root in unsolved grievances and their branches will become dispute. I know of a company which never bothered 1,000 employees, but they had no department. They were manufacturing this thing. Then there was a big issue, and what happened was the workers went on strike, the police were called on, and with these castings, that very, very heavy, the 40 police people were lying unconscious. And the next day company releases ad that we require dynamic industrial relations person. This is called reactive IR. Can we not do it beforehand? So prevent the problem in the birth stage. Understand what's happening. That does not mean that you try and break some of the people and tell them, why are you fighting for others? Whatever are your demand, I will meet. No, don't try that. Let there be a strong people. Build on trust. Annual increment is subsistence allowance? No. No annual increment is required to be given in subsistence allowance. Even as it exists today also. No increment, because the increments are given provided he is working. He is not working. And if tomorrow the charges are not proved and he is reinstated, then the entire money, including what benefit he would have got, they will have to be given. But not. But if your thing is upheld by the law, then probably nothing is payable, like annual increment and all that are not payable. So as I was talking to you, take a proactive stand, understand human relations, maintain the dignity of the people, treat them like reforming an employee who otherwise cannot be sacked is, I mean, it's your opinion. So reforming employee, yes, it has been, my feeling is, yes, reformation is possible. People change. Today, I always challenge the people, show me 5 companies in Maharashtra who are on strike, except public sector, government department. Because people have realized today in the charter of demand, the union raises a demand, please ensure that my company is in existence till I retire. People are worried. By the time I retire, whether the company would be existing and what happens to my gratuity. So people have realized, the blue collar workers, the workmen per se, employee per se, they have realized that there is need that industry should survive. I used to always say in Marathi, of course, I will give a running translation. And this was not my sentence. This was a sentence by one of the most famous union leader, Dattaji Salvi, who was a founder of Bharatiya Kamgar Sena. He used to always say, in every factory there is a chimney and the smoke comes out. That smoke from the company chimney should come out on continuous basis, because the smoke coming from your chulla, that is your where you cook your food, is directly connected. If this discontinues, this won't continue for a long time. And today, after pandemic, people are more worried of saving their jobs. But only my advice to employer would be, don't take disadvantages beyond a point of the situation. Respect them, they will respect you, you respect them. And based on atmosphere of trust, build the industrial relations. Then you don't have to worry. And then also make sure that the law, whatever the law of the land, you follow in letter and spirit. So now government is also rising to the occasion, and they are trying to make as simple as possible. And therefore, ladies and gentlemen, it is my honest appeal that people are your important asset. So treat them as asset. If you treat them as a liability, they won't disappoint you. They will become liability on you. And therefore, but have a balance. Give the thing. I'll give you one example of how you can have a proactive IR. One example. Yes, I'm just taking one minute and then finish off. We used to give the washing allowance. If you go for a half day, I used to deduct half day washing allowance. My union leader told me, sir, does that mean that I should wash only pant and not shirt? I said, think whatever you want. But I'm connecting it with the attendance. Attendance will go up. I said, I'm giving you, I asked him fundamental question, tell me why should I sign 3-year settlement? Because I'm taking care of increase in your skill by way of giving you annual increment. I'm taking cost of living by giving you DA, and I'm also taking care of profit sharing by way of bonus. So why should I sign the settlement? Still, I had to sign the settlement. But with that, what happens is when you talk to them in this particular manner, with respect, understand whatever is possible, then things will be all right. So this is what I had to say. Yes, I know there were a couple of questions were answered, couple of were not answered. Those which are not answered, I would suggest, please write an email to me and I would answer your questions, make an attempt to answer those questions. Email ID, Jaiprakash Kabra, JAIPRAKASH Kabra, KABRA @yahoo.co.in. JAIPRAKASH Kabra, KABRA @yahoo.co.in. Mobile number 98213-42325. You are free to ask me your queries either on mobile or through email. And I will make an honest attempt. I don't claim I have answers to all the questions, but together we will make an attempt and try and find out the answer. So I have enjoyed every minute of being with you. Thank you very much, and God bless you. Good night.
Thank you everyone for joining in. Thank you, Kabra sir, for this wonderful session. Well, just a quick check-in. Kabra sir is also delivering a certification workshop in preventive proactive IR with new labor codes. That's
where we
happening in
will be dealing
January.
at length.
Yes, it's a 5-day workshop, so you can certainly find the details at samsaraomc.com website. I've sent the link in the chat, and looking forward to seeing all of you there. Thanks once again for being a part of the session. Thank you, Kabra sir.
Thank you very much. Thank you. Thank you. Thank you. Thank you.